think you're gonna let him do.
Okay.
There we go.
Hello. How are you?
Yes, sir.
Okay, what case or cases do you have?
Let's see. I'm showing here 097 portfolio in Carrera. Then I'm showing a 106 Midland and Pinell. And I'm showing a 058 LVNV in Corona.
Okay.
That's not a lucky name to have right now.
It's just those three?
Yeah, I think so.
Yes,
Okay.
they're all defaults.
Okay. First one I have on top is Portfolio versus Luis Carrera.
Okay, I have that shown here.
So I guess I would get the Zoom app. Is that right? On my phone?
Yes. If you go to the Apple store,
Mm-hmm.
you should be able to get it. If you go to the
Okay. Are you ready on that one?
Yes, sir.
Okay, proceed. I'm sorry.
Oh, you're fine, sir. This matter concerns a credit card account in default. This account was originated between Synchrony Bank, formerly known as G Capital Retail Bank, and Mr. Luis Carrera, defendant, back in March of 2017. It was thereafter subsequently closed and charged off for being in default in December of 2018. And the amount at such time being $2,273.07. The account was then sold, signed, conveyed, and transferred from Synchrony Bank to Portfolio Recovery Associates plaintiff, who's the current assignee owner of said account, who brings this claim for such liquidated damages on said defaulted account. Having perfected service upon defendant and return of service having been filed with the clerk of the court for sufficient number of days, no answer having been filed by defendant or appearance otherwise, and within the time period required by law, we filed our motion for default judgment, providing the court with our certificate of last known address, non-military declaration as to defendant, as well as our affidavit regarding said account and our business records relative thereto, which identifying the account statements, the amount sought as owing on the defaulted account, and again, which are sought in our petition and in our proposed default judgment, $2,273.07. No attorney's fees, no pre-judgment. We are seeking 5% post-judgment in this case.
Okay. And I have signed that judgment.
Thank you, sir.
And next I have Looks like Midland Funding versus Ralph Pennell.
Yes, sir.
You may proceed.
This matter also concerns a credit card account that was originated between Synchrony Bank and this time Mr. Pennell defendant back in September of 2014. The account was then subsequently closed and charged off for being in default, failure to comply with terms of payment in the amount of $5,903.28, and then subsequently sold, signed, conveyed, and transferred from Synchrony Bank to Midland Funding LLC, who brings this claim for such liquidated damages on said defaulted account as plaintiff, owner, and assignee of said account. Perfection of service upon defendant has occurred, and return of such service has been on file with the clerk of the court for sufficient number of days. No answer or otherwise appearance having been made by defendant in this case within the time period required by law. We filed our motion for default judgment in this case, providing the court with a certificate of last known address and non-military declaration as to defendant, as well as our affidavit as to the account and business records of plaintiff in this case, which are inclusive of the account statements that were provided by Synchrony Bank to the defendant, which show that the amount due and owing as of the date certain of closure on said account is the amount as claimed and sought in our petition, $5,903.28. We've also presented the court with a proposed default judgment for said amount, and for those reasons and based on such claims, with also a 5% post-judgment being sought. No attorney's fees, no pre-judgment.
And that judgment is signed.
Thank you, sir.
And I think the last one and the next one is LVNV Funding versus Heriber Corona Cervantes.
That's correct, sir. That's what I have.
And you may proceed.
Yes, sir. I'm showing this to be a credit card account default matter in which Citibank, the originating creditor, and Mr. Corona Cervantes entered into a credit card account back in October 2017. Said account was subsequently closed, charged off in November of 2018 for being in default for failure to comply with terms of payment. The amount due and owing as of that date certain being $1,777.33. Said account was then sold, signed, conveyed, and transferred to current assignee owner, LVNV Funding, who brings this claim for such liquidated damages sought on the defaulted account as owner and assignee thereof. Plaintiff in this case, having perfected service upon defendant in this case and return of service have been filed and on file with the clerk of the court for sufficient number of days. No answer or otherwise appearance have been made by defendant in this case within the time period required by law. We thereby filed our motion for default judgment in this case. Said default judgment provided the court with the certificate of last known address as to defendant, as well as a non-military declaration as to defendant. We provided also our affidavit as to the account, as well as the business records under said account, which can identify the statements that were rendered to defendant by the original creditor. Such statements identify the amount due and owing as of the default and the closure of said account as the amount sought and claimed under our petition, as well as our proposed default judgment in this case. And said amount again for purposes of the court, having been sought, is, I think I just had it open there and closed it. Where's the default? There it is, $1,777.33 plus post-judgment, no attorney's fees, no pre-judgment sought.
And the number again was what?
$777.33. No attorney's fees, no pre-judgment, 5% post-judgment is sought.
Okay. And that judgment is signed as well.
Thank you, sir.
Okay.
That concludes my business today, as much as it has been before the court. Always an honor to see you, Your Honor. And I hope you all stay safe. And I hope the watermelons keep popping. Last time I was through there, I only saw about 2 or 3 people on the side of the road. I said, they need to start getting those suckers up out of the ground. Usually I see at least a dozen people out there.
Right. Okay, thanks for your help.
All right, I'll see you all Wednesday. Thank you, sir.
Okay, we'll see
Bye-bye.
you. Bye. Let's leave this open for now, do you mind? Because I want to,
Yeah, we can do